and the welfare of the child, Your Lordship. And these factors have to be taken consideration by this Honorable Court, Your Lordship.
Is your client now ready to come down, restrict your Facebook time and divide it between child and wife also? Is your client ready?
Indeed, Your Lordship. If the divorce should not be granted, Your Lordship, that is the ultimate condition.
You will give undertaking.
Indeed, Your Lordship. Your Lordship, as we know, under this particular special leave petition has come to this honourable bench under the Article 136 of the Supreme Court, and this and the Honourable Court have all the powers, have all the plenary powers and unlimited powers. The Honourable Court, in its discretion, can refer the matter to mediation or conciliation to save the institution of marriage itself, Your Lordship. Your Lordship, if the Honourable Court permits, I would like to deal with the fourth issue, Your Lordship. Much obliged, Your Lordship. Your Lordship, the fourth issue in this case is what guidelines should be framed on the use of the Facebook by the judges. Your Lordship, as my co-counsel had contended, that we cannot deny the fact that Facebook is something which has become an intrinsic part of our society. It has become an indispensable part of the world. So, putting a complete restriction, putting a straight-jacket blanket restriction on the use of the Facebook by the judges would be unfair, but it should be regulated in a manner that it does not hamper the conduct of the judges in any way, Your Lordship. Your Lordship, in order to assist the court in this particular issue, the appellants have made two kinds of guidelines, that is the general guidelines and the specific guidelines. Your Lordship, general guidelines are in relation to the general conduct of the judges, and specific guidelines are in relation to the conduct of the judges, particularly when it comes to the online social networking sites, Your Lordship. Your Lordship, when there is an ambiguity or in cases where the general specific guidelines do not serve the purpose, then the general guidelines would come to the rescue and they can be taken recourse to. Your Lordship, I would like to ask the Lordship to refer to page number 24 of the memorandum, Your Lordships. Much obliged, Your Lordship. If Your Lordships permit, I would like to deal with the general guidelines. Your Lordship, these particular guidelines have been taken by the various international conventions and from the rules of various other countries. As Your Lordship, in our country, when it comes to the conduct of the judges in relation to social networking site, it is a grey area and there are no conduct rules which are prescribed as to the conduct in regards to the social networking sites. Your Lordship, the appellants have derived these authorities from the Australian Principles of Judicial Conduct, American Bar Association Formal Opinion, Kenyan. Indeed.
In the prayer, what you have stated is the judges do not have right to use Facebook or similar social network sites.
Indeed.
If that is to be done, then where is the question of leaving the guidelines arise?
Your Lordship,
when they do not have right to do it, if the observation is made to that extent, then where is the question of leaving the guidelines arise?
Your Lordship,
by that prayer, are you not invading our freedom?
Your Lordship,
you want to take away our freedom?
Your Lordship, the ultimate contention is that the judges should not have a right to use social networking site, but it totally depends upon the discretion of the the judges. Your Lordship, I would like to cite a case of Vishaka case where the guidelines were framed. Your Lordship, just a simple example.
Counsel, your argument is like this: if an accident causes in a car, so the judges should not sit in the car?
Certainly not, Your Lordship. Your Lordship,
you are saying, don't use the Facebook, restrict your freedom, right?
Your Lordship, it is just in order, I would like to make one contention, Your Lordship, just one humble.
Then, if this court comes to the conclusion that the judges should not have make use of this Facebook, then if that is the case, where is the question of taking guidelines arise?
Your Lordship, I would like to give reply to this question. Your Lordship, we can take the famous case of Vishaka, where the rules and the guidelines were framed when it came to the sexual assault in the workplaces, Your Lordship. Your Lordship, when the sexual assault in the workplaces take place, that is when the court had framed guidelines when it comes to this particular issue. Your Lordship, that doesn't mean that the court says that sexual assault should happen. But it indeed says that sexual harassment should not happen at workplaces. But in case if it happens, these are the guidelines which will come to the rescue. In the similar manner, Your Lordship, in this particular case also, we contend.
Which you are narrating that has not been played like that.
Your Lordship, that the council wanted to say that the ultimate contention is judges do not have a right to subscribe to Facebook. But we cannot deny the fact that Facebook has become...
In case, that has not been mentioned here. They have not been mentioned.
Your Lordship, because it depends on the discretion of this honourable court to decide whether these guidelines have to be taken into consideration. I beg your pardon. Your Lordship, now we know that making a Facebook account is not something which is a very difficult process. Anyone who is above the age of 13 years can access Facebook and can make an account of his own. So, as the post of...
You create an analogy between sexual assault and open shop.
Certainly not, Your Lordship. Your Lordship, I am just trying to say that when the guidelines were framed in the Vishakha issue, they were in order to protect something which is wrong and which should not have taken place. Here also we want to say that the judges should not use Facebook, but because of the importance and because of the prominence it has in the present era, in case the judges uses the Facebook, then these are the guidelines which should regulate their conduct when it comes to social networking site. That's the only contention of the appellate. But these guidelines are just in order to assess this honourable court, and it totally depends on the discretion of the honourable court to whether to accept or not to accept these guidelines. May I proceed with the specific guidelines, Your Lordship? Much obliged, Your Lordship. Your Lordship, I would like to bring into your attention the page 26 of the memorandum, where the first specific guideline has been mentioned. Your Lordship, it shall be the duty of the judge not to make public comment on pending cases or indulge in any political activity in the social networking sites. Your Lordship, the second guideline would be the duty of the judge not to demean the judicial office in the social networking site. Because, Your Lordship, Facebook is a platform where one can post their photographs, can update status, can make any comments which can be seen by everyone, Your Lordship. And we know that as judiciary is a temple of justice and the public repose a lot of faith in the judiciary, such a conduct which demeans the judicial office.
How putting a photograph demeans? Every day our photographs comes in the newspaper whenever we give some day.
Your Lordship,
yesterday I inaugurated your one Moot court and my photograph came today. That is demean.
Your Lordship,
Putting my photograph in a Facebook, does it demean?
Your
Now
Lordship,
it is more transparent. I don't remain invisible. My face is known to people.
Your Lordship, I would like to contend that photos and posts which are favourable or unfavourable to someone should not be
Who has
posted.
to decide that? Favourable or unfavourable? What is favourable to you may not be favourable for me.
Your Lordship, it depends on the facts and
So
circumstances of
generally you
each case.
can't put it up.
Your Lordship, I would like to have 2 minutes.
2 minutes.
Much obliged, Your Lordship. Your Lordship, the third specific guideline would be duty of the judge to make necessary disclosure of the nature of the social networking sites. Whatever kind of social networking sites they are using, because there are certain chances, there are certain social networking sites where they are in a kind of blogs where you can post your comments, your views relating to certain issues, and there are certain other social networking sites, Your Lordship, where a scope of bilateral conversation is possible. Your Lordship, the ultimate contention is it shall be the duty of the judge to make the disclosure of such social networking sites where the nature of the profile on that social networking site is personal. That is the contention. Your Lordship, one important guideline is duty of the judge not to obtain information of the witness, party or lawyer from the social networking sites. Your Lordship, the last specific guideline would be duty of the judge to disqualify himself from proceeding if his social networking relationship create bias or prejudice. If the relationship between the judge and the party or the lawyer appearing before him and he is a friend on the social networking site, if it creates a likelihood of bias, Your Lordship, the judge should disqualify himself from trying such case and should disqualify himself from the proceedings. Your Lordship, I would like to go to the prayer, Your Lordship. Much obliged, Your Lordship. Whereof in the light of the issues raised, arguments advanced and authorities cited, it is humbly prayed before this honorable court may be pleased to hold, adjudge and declare that judges do not have a right to use the Facebook and social networking site, but in case it depends on the discretion of the court, and if it does, it should be in a regulated manner, Your Lordship. And Your Lordship quashed the order dated July 2014 passed by the Family Court, quashed the order dated August 2014 passed by the High Court, set the proper guidelines for the usage of the social networking sites by the judges, and direct the Registrar General of the Supreme Court and other High Courts in order for the proper implementation of these guidelines, and direct the Law Commission of India to make necessary drafts regarding the ethics and conducts of judges and pass any other order as this honorable court may deem fit in the order of fairness, equity and justice.
What happens merely by setting aside the High Court order?
I beg your pardon.
What happens merely by setting aside the High Court order? Without interfering with the trial court order? This is against you. Still remain. Or it will set aside the judgment of the High Court. That's all.
Your Lordship, in the prayer, there is also a prayer to quash the order of the Family Court as well.
That's all you
That is also a prayer which is there. Much obliged, Your Lordship.
Thank you very much.
A couple who were married for 3 years. They met in New York while working as financial analysts in an investment bank. The couple also had a girl child, and 3 years subsequent to their marriage, the couple shifted to Chingalore, India along with their daughter. 1 year after moving to Chingalore, there grew differences between the couple. This was due to Meera's incessant chatting on Facebook with her US-based colleagues. It eventually led to husband Sheesh to file for divorce in the family court, Chingalore, alleging wife Meera for inflicting mental cruelty under Section 13, Clause 1, Subclause 1A of the Hindu Marriage Act 1955, as her persistent chatting on Facebook deprived him of the happiness of having a family life. The family court granted divorce to Sheesh on July 2014, but wife Meera appealed against it in the High Court of Chingalore under Section 19 of the Family Courts Act of 1984. The High Court also dismissed her appeal on August 2014 by upholding the divorce granted by the Family Court. Later, Meera filed for special leave petition under Article 136 Clause 1 of the Constitution of India before this Honourable Court because one of the judges of the High Court bench was and is a Facebook friend of husband Sheesh. She alleged that the impugned order passed by the High Court to be null and void on the ground of an apparent bias. However, the entire approach of Meera on the use of Facebook is self-serving. On one hand, she asserts her freedom to chat, but on the other hand, she pleads against the judge's use on Facebook. The Supreme Court, however, granted special leave to appeal to petitioner on September 2014 and posted the appeal for hearing before the division bench on October 2014. If your Lordship is pleased, the Council would wish to move to the issues. There are 4 issues, your Lordship. The first issue is whether judges have a right to subscribe to Facebook or social network on the internet and invite or accept friends. The second issue is whether the impugned order dated August 2014 passed by the High Court in appeal under Section 19 of the Family Courts Act 1984 was null and void. The third issue is whether chatting on Facebook by Meera amounted to mental cruelty under Section 13 Clause 1, Subclause 1A of the Hindu Marriage Act of 1955. And the last issue is what guidelines should be framed on the use of Facebook by judges. If your Lordship pleases, the Council would wish to move to the pleadings. Much obliged, your Lordship. The first contention is that judges do in fact have a right to subscribe to Facebook or social network on the internet and invite or accept friends. It is humbly contended that judges have a right to subscribe to Facebook or any other form of social network on the internet and invite or accept friends in exercise of their fundamental right under Article 19, Clause 1A and Article 21 of the Constitution of India. There is no law in India which debars a judge to social network or accept or invite friends. Under Article 19(1)(a) and Article 21 of the Constitution, which respectively talk of the freedom of speech and expression and the right to life, judges are no exception to exercising these rights as against any ordinary citizen. The right to socialize is an inferred right from under Article 29, which judges have an equal right to exercise. Also, what must be differentiated over here is a friendship which is formed online and a friendship which persists in real life. I would like to bank on the case of Quigley Corporation versus Caucus, which was held in 2009, where Quigley alleged Caucus and certain other people on the side of the defendants that they were trying to issue proxies in the shares of Quigley's corporation, and he tried to establish a connection between the defendants and a third party by saying that these people were associated through Facebook. It was in this case that the court held that there are certain parameters which need to be taken into consideration when you distinguish a real life friendship and a friendship online. Certain parameters of making these demarcations were a degree of proximity, which is clearly lacking in this case. There is no proximity between the judge and Sheesh in the present case. Also, there needs to be a feeling of effectivity and an emotional connect, which is again lacking in this case. There is no emotional connect between the judge and Sheesh. Third is a feeling of cognizance. Your Lordship, this is where I wish to tell you that given that Facebook is such a prevalent feature in our lives now, there is so much of mutuality and so much of overlap in relationships that even if I and a certain person are friends, he will have several other friends who will turn up to be my mutual friends, and so on and so forth. Now, if you start considering all these relationships to be equally important to someone I know in person and know every day and have these parameters satisfied with, there is proximity, there is effectivity and there is cognizance, then there is no essential difference left between a Facebook friendship and a friendship which undergoes in its real life. Hence, it is very important in the present case that it be established that respondent Sheesh only had a very frivolous relationship with this judge, even if it can be counted as a relationship.
Counsel, that is the bad gesture. The gesture you made is a bad gesture. It is mannerless gesture.
The council would wish to apologize.
The younger generation should mind it.
The council would wish to apologize about it. If your Lordship is satisfied, the council would wish to move to the next. It is humbly submitted that while exercising such a right, there should be no miscarriage of justice, your Lordship. And in the present case, we are saying that Article 19, Clause 2, puts reasonable restrictions on judges to exercise these rights. And they are set by standards of public order, morality and decency, which have been fully complied by the judge in the present question.
In Article 19, the word morality, what has been there used?
Indeed, Your Lordship.
Whether it covers bias or not?
Indeed, Your Lordship, it does cover bias when you talk of judges and the judiciary. But in the present case, there is no form of bias, because the essential requirements of fulfilling a case of bias, like is stated in the previous contention, that there has to be, it has to be established that there were certain parameters of degree in this relationship which are clearly lacking, and hence there is no real relationship.